We are so grateful to the jury for selecting our article, Antitrust Regulation of Copyright Markets.
Our article, which argues for more behavioral oversight of mergers in the media and entertainment space, feels even more timely in this era of vast content consolidation. Last year, private equity company New Mountain Capital acquired one of the two big animating examples in our paper, the performing rights organization BMI. Music back catalogs are being bought and sold by other private equity companies at a rate never before seen. And all of this is happening at a moment when content companies, following a period of rapid M&A activity, are greenlighting fewer projects than ever before, all while raising prices, which are the very hallmarks of a classical understanding of merger harm.
How did we get here? Our article argues that for too long, antitrust and copyright law has worked in silos, and that neither area of the law has been sufficiently equipped to deal with the rise of the large-scale copyright aggregator and the big tech loss leader. The prevailing wisdom has been that competition problems in the content space should be addressed through antitrust alone. However, both the Chicago School approach, as well as newer so-called neo-Brandeisian approaches, struggle to deal with the particular policy challenges of market power in copyright markets, where what seems to be a super competitive price may or may not actually be necessary to fulfill copyright's goal of incentivizing the production of new creative works. Antitrust preference for structural rather than behavioral remedies ignores why content markets in particular have trended towards consolidation over the course of the past decade, and the very real risk-spreading benefits that consolidation might have in the risky business of making cultural works.
Our article also illuminates an obscure area of the law that combines antitrust enforcement with sensitivity to copyright's policy goals, the consent decrees that manage the music performance rights organizations ASCAP and BMI. Our analysis of all of the prior rate adjudications to date, which have been brought under the decrees, show that far from an outdated relic that parties no longer rely upon, parties continue to call upon rate court judges to adjudicate disputes, especially as new technologies and new modes of disseminating content arise. Our proposal stands starkly in contradiction to renewed current calls to sunset those decrees. Our article argues instead that the DOJ should employ more behavioral remedies and more consent decrees to regulate the content industry, applying it to cases of price fixing, pooling, proposed merger activity, and loss leading practices.